Carolina criminal defense attorney John Mobley is on the program today. John, good to see you. Happy Monday to you. If I could I just start with your overall assessment of this case? What are you seeing based on the facts as we know them right now?
Well, Julie, I got to call it like I see it. While I do agree that popcorn is saturated in fat and can certainly elevate someone's cholesterol levels, there's no legal theory in which throwing popcorn at someone is going to justify using deadly force. I mean, I think that's fairly straightforward. I mean, we see these cases where you have a individual with a firearm, a handgun, shooting and killing an unarmed individual and claiming self-defense. And the law's not designed to work that way. I mean, you can't, if you're going to use deadly force and it be considered justified, there's got to be a real serious threat to your life or serious bodily injury. Not just you got to an argument with somebody, or you might get into a fight with somebody, or somebody yelling and screaming at you. All those things don't justify using deadly force. And we're just seeing that more and more in these cases because, and quite frankly, I think that's the only defense they can have in this case, but certainly not justifiable homicide. I just don't see it in this case at all.
I hear what you're saying, John. Tell me, does anything change with your analysis if Curtis Reeves is testifying that he didn't know it was popcorn, that just some object's being thrown at him and he's firing back? Does anything change for you in that regard?
No, not in these circumstances at all. I mean, I think we have to keep in mind there's always an element of reasonableness in a person's perspective regarding the threat. And just a defendant saying, well, I didn't know what it was. Well, he didn't know what it was, but he didn't say he thought it was a knife. He didn't say he thought he saw a gun. He just said, okay, I didn't know what it was. Well, if you don't know what it is, that doesn't justify responding deadly force. There's got to be some real indicator that there was a deadly weapon used or something that was going to cause serious bodily injury. So him just saying he doesn't know what it was doesn't get the job done in my assessment.
I'm really curious if his team is going to choose to put on a defense or not. I'm curious if they're going to talk about the fact that he served in law enforcement for years and if that at all contributed to that reaction, just based on his training, what he's seen in the field. I mean, he was very high ranking. He left as captain, the police department in Tampa, retired. And I'm wondering if they're going to call any experts. Would you, John, let's say you were representing him and you want to kind of help the jury understand that, look, his split-second reaction is going to be different than an ordinary citizen's because of what he's used to and the training that he's been, I guess, inundated with, throughout his career.
Well, I think if anything, that actually works to his detriment. I mean, he has been trained. He's been trained in de-escalating situations, dealing with suspects, dealing with violence. And I'm certain that no one who trained him would say, your response to a suspect throwing popcorn at you would be to discharge your service revolver and shoot them and kill them. No one's going to say that. I mean, so I think that actually works against him. I think a better bet in this particular case is to really talk about his age. Maybe if he has a substantial amount of health issues, he's old, he's frail. You try to maybe argue that he does not have the luxury of waiting to see if someone can get the drop on him. Because just so we're clear, I mean, self-defense can be different for different people. If you're a 200-pound man who's young and in good shape, you're not going to perceive a threat the same way maybe a single female with a child. So let's say you're a 98-pound woman with a small child and you're being threatened by a man. Well, I think you certainly have a greater degree of a fear of risk of harm. And I think the law would in that case say, well, hey, you don't have to wait for this guy to get the drop on you, because once he does, you have no real way to defend yourself. In a circumstance like that, you have a broader range. So I think the only equivalent this man would have, the defendant would have, would be to maybe play on his age, play on him being frail, play on him being weak. But I just don't see that he has portrayed himself that way in the interviews and the way he handled himself. And so I think that's a little bit of a problem for him.
Speaking of interviews, John, Chad Oulson's wife, Nicole, came on Vinnie Politan's show, Closing Arguments, just a couple of weeks ago. We have a clip from that interview. Let's take a look together.
I think about Chad every single day, throughout every day. Something will remind me of him. Something Lexi will do will remind me of him, and it never goes away. And, I don't want his memory to go away, but I don't want to keep reliving the day and the incident and how it happened. And I would like to find a little bit of, justice and peace from the trial. So hopefully that will happen soon, and I can, not just me, but his family can have that peace as well.
She'll be a witness too, won't she, John?
A very sympathetic witness. Those kind of details, those types of what I call intangibles, are not good for the defense, because they have what I see as a very sympathetic victim that got killed. He wasn't alone in the alley. This was a very, very nice day for this couple. This man had a young family. He had a wife. He was on a date with his wife in the middle of the day. So he would not be someone that I think a jury would perceive as a threat. You have a very sympathetic wife who witnessed her husband be gunned down before her eyes, who's got a young child to take care of. She's going to be emotional. She's going to be crying. Those things are a problem for the defense. There's no doubt about it. So I think they're going to have a very, very tough road to try to argue self-defense, and I think they're going to have a difficult time getting the jury to want to acquit their client, which is always an issue, because typically, what I like to believe is, if the jury wants to acquit your client or give your client a good result, they will apply the facts in a way to get that result. But under these facts, with this type of victim and this type of widow and this type of defendant, I don't see those intangibles working in their favor at all.
Hear what you're saying. Tell me, John, we know today the jury selection, according to our field crew who is there at the courthouse, it started around 11 o'clock today, going slowly so far. But as soon as this jury is seated, we're going to see opening statements and the case is going to begin. Tell me, if you're on the defense side representing Curtis Reeves, who ideally would you like to be on your jury?
Definitely elderly people. There's no doubt about it. You want elderly people. Elderly men, elderly women. Otherwise, I think we have a hard time with this one, because you want people that identify with the defendant and maybe won't be so, identified with the widow and the victim. So that's going to be a tough one, because, people with young families, you don't want them. You don't want widows. You don't want young women. I think you have a hard time. I think it's more about who you don't want than who you want in this case.
Sure.
Because I think that the window for who you want is a very narrow, very, very narrow field. I think you only want people that are going to identify with this old retired cop. And I think even former cops might not be good. I think most former cops will say, hey, we were trained. We don't kill people in these circumstances. He could have walked away. He could have moved seats. There was nothing to indicate this is something that, there was no arrest. There was nothing to indicate the use of deadly force. So I think it's really a matter of keeping off the people you don't want. And if you get lucky and have a few retirees, old women, old men that are going to identify with the defendant, you're lucky if you can get them.
Sure. Yeah, you said it well. We always say in the profession, it's jury deselection, right? Even though it's technically called jury selection, you're eliminating all of those people that you don't think are going to be favorable for whichever side of the case you are on. John Mobley, so happy to have you this Monday afternoon. Thank you so much.